Welcome to A Taste of Justice. I'm Professor Angela May Kupinda. Look, I am so excited to tell you about my class meeting I had today with my First Amendment law students. As you know, if you watched the preceding 2 or 3 clips, my students are working on a very interesting exercise. They are preparing, or they have prepared, student position statements on current First Amendment conflicts. And each day in class, we have a group who presents. They present a 5-minute presentation on their position statement, and then they engage with questioning from their classmates and from me. This exercise has several goals. One is for them to review the First Amendment, which is tested on the bar exam. Another goal for them is to apply the First Amendment to current First Amendment conflicts. And we are having lots of them right now in 2021. Another goal is for them to consider viewpoints different from their own, as good lawyers and citizens and persons should do, right? To consider those viewpoints and to engage professionally with others who may disagree with them. So we had an exciting time discussing these topics. And of course, the exercises have other goals, also other teaching and instructional goals, but you can look at some of the earlier clips where I go through all of those very carefully. So today, I want to tell you about the position statements that were presented, and there were 6 of them presented in class today. Some of them relate to some of the earlier discussion we had about social media and whether social media may constitutionally ban individuals from their platform. And so I won't be going through all of the points, but take a listen, watch the clip right before this one, and you will hear more of that, more of the background, more of the factual background, and more of the arguments on each side. What I want to do today is I want to tell you about these 6, and I want to tell you what is different or unique about these 6 student position statements as different, perhaps, from the ones that we covered last time. Okay, so let's get started. Now, well, let me go back a minute. I'm a professor, Mississippi College School of Law. I don't know if I told you that, but that's for informational purpose. All views, all interpretations here are my own. I'm not giving you my students' names to protect their privacy. I am summarizing their positions based on what I read in their written document and what I heard them say today. Hopefully I'm getting it just right. If not, my apologies. And again, I will not be giving you their names to protect their privacy. Okay, let's get started. The first student position statement is this: Twitter and Trump, why I believe social media sites can suppress information. So in her position statement, she argues that social media sites can suppress various information, can remove individuals from the social media site. She argues this is not in violation of the First Amendment. Now, there were a couple of course, she went over the competing arguments. She says one competing argument is that by banning some individuals, social media is taking a position perhaps on their viewpoint. She says one approach could be to say okay, we're going to ban everyone who is speaking on a particular topic. For example, everyone who is speaking on the election would be banned. Therefore, they do not have to ban particular individuals who may make comments that the social media platform finds to be untrue or to incite violence. She says another approach that social media could do is that they could just allow everything to be said, regardless of the consequences. She does not agree with either of those positions. She says that she believes that social media can ban former President Trump. Now here, in her position statement, she makes a reference to a case we talked about earlier. The case was called Abrams, and in that opinion, Justice Holmes, who had been very much in favor of governmental regulation and suppression of speech as related to war, he disagreed in that case. He said, look, this case involved two silly men throwing some flyers out of a window in New York City. There is no indication here that their speech would actually lead to violence. So in her position statement, she says that former President Trump is not akin to these silly unknown men because he was the president of the United States, the former president now of the United States. So therefore, she believes that social media had an even greater basis to remove him because of possible consequences from his speech. Now, she even goes a step farther. She argues that social media had a moral obligation, even though it may not have had a legal obligation, maybe not. She said that it had a moral obligation to prevent misinformation and to prevent the encouragement of violence or illegal action. So in her position, she believes that the removal of former President Trump from social media was not a violation of the First Amendment. What do you think? Do you agree with her? Do you disagree? Do you believe that Twitter had a moral obligation to do so, even if it did not have a legal obligation? And do you agree that Twitter did not cause an affront to former President Trump's First Amendment rights because social media, these are private companies, not the government? Let me go to the second one. In the second position statement, he argued social media's right to associate by banning, blocking, and stopping users from the marketplace. Now, he also adds a couple of additional or different points from what we have discussed before. I've got to go take a swallow of water. Hold on one second, I'm going to pause. In his position statement, he argues that, he points out that some states are attempting to pass laws that would prohibit social media companies from blocking or banning users from their platform. And he says that these laws are unconstitutional, the ones that are being proposed, because social media, he argues, is a private company. These are private companies, although the public may use them or rely on them for getting their messages out. Now, he says, of course, some may argue that the marketplace of ideas ought to flow just freely. However, his position is that these laws that are being contemplated, they actually are an affront to the First Amendment rights of the social media companies. He says these companies are private companies, and private companies have a right to associate or not to associate with certain ideas. So therefore, he says that the states cannot force social media companies to allow all users, regardless of the content of their message. Okay. What do you think about that? Do you agree with him or do you disagree? I've listed all of these positions in the text box below so you can keep your own record in terms of which ones you agree with as we go. So for now, let me go to the third one. The third student argues that Donald Trump's Twitter ban for incitement of violence did not violate the First Amendment because it was carried out by a private company. However, if it was done by the government, it would not violate his First Amendment rights. He says Twitter is not the government. Twitter is a private company, and that private companies also have speech rights. That private companies like Twitter, they have terms of service, right? When you join Twitter, you click that you have read and you understand the terms of service, and that these terms of service are governed for this private company. Now, he says that an additional thing he adds in his argument is that he says even if Twitter is the government, okay? Now you may say, how is Twitter the government? Twitter is a private company. But if you look at the first 3 or 4 con law clips, not the First Amendment, the con law clips, we talk about the concept of state action. And some people may argue that Twitter has essentially become like the state. Now, I haven't thought that all the way out, but I imagine you may see arguments like that in the near future. But he says, even if it's the government, even if Twitter has lost its private status in some way because it's so open to the public, he says even then, former President Trump could be banned because of Brandenburg. Now, we learned that not all speech is protected under the Constitution. There are unprotected categories. One category of unprotected speech is speech that advocates illegal action. And the modern day test for that is Brandenburg. So he argues here that Brandenburg said that speech that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action, that it is unprotected and government may regulate it. Now, I had a question for him. I don't think we really got to in class. I had so many other questions, and of course, some of the other students had questions too. I'm wondering if under Brandenburg, and if this is the government, how long does the government have to wait, right? How long does the government have to wait before it could take action against speech? in some of the cases that we've talked about, the court said, do you have to wait until the fire breaks out? If government sees a person running with a match, so to speak, can they be regulated then? And I think that perhaps his position statement is introducing these other issues that, what do you think? Do you agree with him? Do you disagree with him? Do you agree that even if you can say that Twitter is the government, that speakers can still be banned based on the Brandenburg test, that speech that is that incites or is that produces imminent lawless action and is likely to incite or produce such action is unprotected? Make a note as to whether you agree or disagree. Let me go to the next one. The next student argued Facebook's controlling of what users post is not a violation of any Facebook user's First Amendment rights, and Facebook itself also has First Amendment rights to exclude messages on the platform. Now, her argument is similar to some of the others, including her competing arguments. But I want to point out something I found, of course, all of this is interesting to me, but one part of her position I found especially interesting. So she says Facebook can block speakers, they can block individuals, they're a private company. The cases that she uses are, the first one is Citizens United. Now, do you remember Citizens United? Citizens United was considered a very controversial position. In Citizens United, the court held that private corporations have a right of political speech in Citizens United. Now, the ruling, the court, let's say that the more conservative members of the court were more on board with Citizens United than the more liberal members of the court. But now Citizens United seems to be causing some harm, perhaps, to conservative viewpoints. Under Citizens United, a corporation has the right of political speech. So therefore, the private corporations of Twitter or Facebook or what have you, they would have this right to speak or not to speak. And if they choose not to speak, then that would mean under Citizens United that they have the right to ban users, to ban speakers from their platform. So it seems that Citizens United now hurts or potentially harms the interests of those that advocated for Citizens United. I just find that very interesting. There's another case she relies on. She relies on Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, a 1995 case. So in that case, the government allowed a private group to plan a parade. And I believe it was possibly the St. Patrick's Day parade. This private group that was planning the parade, they did not want to allow the LGBTQ group to participate. And the LGBTQ group brought suit. And they said, this is a parade. This is a public. This is for the public. We cannot be excluded based on this criteria. But the court said that the authority for the parade rested with a private group, and the private group had a right to associate or disassociate with certain ideas. So therefore, the private group could exclude this other group based on sexual orientation. Now, that case that was seen as a case that really benefited conservative viewpoints now may hurt the position. That case, the student argues, apply it. Social media companies are private companies. And therefore, just like those who are planning the parade, they can exclude individuals whose viewpoints they do not endorse. And so therefore, she's using the various cases here to counter a more conservative viewpoint. Take a look at those cases. Do you agree with her or do you disagree with her? And the cases that she referenced are mentioned at the bottom in the text box. But that gave me a lot of pause. And in some of the opinions, the court will say that you may like this opinion today, but tomorrow, the application of the opinion, you may find that it hurts your own cause. Okay, we have two more. In this position statement, in both of these position statements, let me go back to say, in both of these statements that are about to follow, the students relied on Section 230 of the Communications Decency Act. Yes, there is a federal act that relates to social media. Google it and read about it. It has been criticized by people from various political positions. Okay, now let's start with the first one. His position statement is, social media is flooded with misinformation, but needs no regulation because it is a marketplace of ideas. So he talks about that he argues we do not really need any additional regulation of social media. He says, of course, there are some positions different from his. Some people say that social media should be subjected to something like the fairness doctrine that you may see in broadcast media, where you have to give different sides of an issue, be fair and give them somewhat equal or similar time. But he says you really don't need that because social media is a marketplace. Social media is a marketplace of various ideas. And so therefore, he doesn't even think it should be regulated about misinformation, because he says people should take what they see there with a grain of salt, and they should use their critical reading and thinking skills to evaluate whether the information is valid or not. In his presentation, he told us all about the various attempts to sway public opinion. He explained it all to us. I probably would not explain it back correctly, but he says there are all types of sources out there attempting to spread false information. So we don't need more regulation. We just need people to be more critical in terms of their being critical readers and being more critical in terms of the information they rely upon. He says it's a marketplace of ideas, and individuals who are in that marketplace will then engage in their own, and regulation is not the word, but that the marketplace will prevail as ideas are rejected if individuals critically consider what they're reading on social media. He says more regulation is not needed. The public should be informed, and its forum should be protected rather than regulated. Now, the next presenter also talked about Section 230 of the Communications Decency Act, that you should really go and Google it and read a bit about it. And his position is this: Section 230 of the Communications Decency Act should not be modified or repealed because of alleged bias against free speech. He says this federal law has been critiqued a lot by people from various political persuasions. He said Republicans have complained about it some, Democrats have complained about it some. It may not be a perfect law, but he says it is a sufficient regulation. The law, and you can read about it, it's to give some protection to social media platforms so that they do not have to guarantee every statement, so that they are not charged or sued based on every statement spoken on social media. He says that if we start trying to come up with stricter laws that to evaluate or regulate social media, he says that it is going to be a slippery slope. And what is in vogue one day is out of fashion the next. So he says the law is sufficient. And it seems his argument is that Section 230 is a sufficient law. Let the marketplace run its course. Do you agree or do you disagree with these final two presenters? Wow, learning is something. The more we learn, the more we see that issues are more complicated than we believe. We see how the First Amendment has been applied in the past. And we see that some cases that a person may think is a great case at one point may later on be a case that does not support their position. This marketplace of ideas, what happens in this marketplace? You know, we talk about the truth being discovered when you let ideas into the marketplace. But while these ideas are bouncing around in the marketplace, what does that look like? What does that feel like? My students are doing such an amazing job. The presenters from today and also the presenters from the earlier position statements. Look, I'm not saying I agree with everything I have heard, but that is not the goal of the exercise for them to persuade me. The goal of the exercise is for them to consider a current First Amendment conflict, to apply the law, the case law from the Supreme Court, to analyze both sides of the issue, and to stand right there, to be present in the room with their classmates, state their position, and accept questions, especially from those who may disagree with them. Look, learning is the pathway to enlightenment to freedom, and freedom to justice, or at least a taste of justice. Subscribe, sign up for notifications. You do not want to miss a thing. More student position statements to come. Bye-bye.